It's not going to be because of the court system. It's going to be because we changed what it means to be an officer in our neighborhood.
Including a DeKalb officer fatally wounding an unarmed naked man with a history of mental illness. WSB legal analyst Philip Holloway is a defense attorney who also maintains a certification as a peace officer. And Philip, while we wait on the GBI's finding on whether this shooting in DeKalb County was justified, can you bring us up to speed on how police are trained to evaluate the amount of force necessary in situations like this?
Currently throughout the United States and here in Georgia, police are taught that when they use deadly force, they must do so only when it's reasonable. And that there's a force continuum. Oftentimes, mere presence of the police officer is enough to calm a situation down. On the other end of that spectrum is the use of lethal force. The fact that someone is unarmed is not necessarily the end of the discussion. It's a factor that must be considered in relation to the totality of the circumstances. The Fourth Amendment requires that any police use of force be reasonable. And reasonableness is not based on hindsight, but rather it's based on the perspective of the officer on the scene, allowing for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving.
Now, there's actually a Supreme Court case that helps guide this, isn't there?
This is all based on Graham versus Connor, and in that case, the court stated that reasonableness is the touchstone. Officer use of force must be reasonable in light of the totality of the circumstances, and it's viewed from the perspective of the police officer on the scene. Therefore, if an officer believes that a suspect's actions place the officer or others in the immediate vicinity in imminent danger of death or serious bodily injury, then they may constitutionally, reasonably use deadly force.
Now, Philip, you've got double training here, both as a defense attorney and as a certified peace officer as well. There's not a lot of time to make this decision most often, is there?
It's frequently made in an instant, and it's made under circumstances that are rapidly evolving. They're fluid. Officers frequently have little or no information on the background of who they're dealing with, whether or not it may be an issue of mental illness, whether or not it may be an issue of drugs or other medication that are affecting someone's actions. So they have to make decisions, very important decisions, oftentimes with very little information to go on.
And they fall back on their training at times like this. And what does their training tell them when it's time to shoot?
Once police officers have made the determination that they need to employ deadly force, their training tells them to shoot to eliminate the threat. They shoot to center mass, typically. Unless there's a problem stopping the suspect that way, then they're trained to shoot to the person's head. They are trained to eliminate the threat, and that translates to shooting to kill. They are not trained to shoot to wound, unlike some other countries where they might be trained that way, such as Israel. But in the United States, they are trained to shoot to kill once they have made the determination that deadly force is authorized.
Oh, you mentioned Israel. Is there indeed an Israel model to deal with situations like this?
Yes, and I believe that we may very well see something like this coming to the United States. The Supreme Court of the United States may very well revisit the question of when police can use deadly force. And if they were to pick another model, I think the Israeli model might be a good way for them to begin, because under that model, the focus is on shooting to wound and not shooting to kill unless it's an absolute last resort. In fact, the police are trained to not even carry their weapon with a round in the chamber, and that reflects their philosophy of not killing someone unless it's an absolute last resort.
And on the other side of this, I don't know of many officers who go out in public now without body armor these days.
Absolutely not. When I first started in law enforcement, we didn't have body armor. We didn't have tasers. We didn't have weapons that were less than lethal. That's another piece of this discussion that needs to be brought up. In this DeKalb County situation, the officer was apparently equipped with and trained to use tasers. That's a less than lethal weapon that is designed to stop someone who is resisting or is presenting a threat to the officer, where deadly force may not necessarily be needed. A big focus of this investigation will be on whether or not it would have been more reasonable for the officer to use the taser as opposed to going straight to his weapon and employing deadly force.
Now, you mix with law enforcement all the time during your job, Philip. What are you hearing from officers on this case?
The officers that I've spoken to have very mixed reactions to this. Some of them reflect some of the general public sentiment that there's no way that this could ever be justified. Some of them say that it absolutely was justified. We weren't there. We don't know what this officer saw, and the judgment call was his and his alone to make. So some officers are squarely on the side of the officer. Some people and some officers are squarely on the side of the deceased and his family, and some are in the middle, which reflects the idea that we really don't know all the circumstances yet, and perhaps we need to sit back and wait for the investigation to run its course before we can reach any conclusions or make any judgments about whether or not this was justified under the circumstances.
WSB legal analyst Philip Holloway, sure appreciate you filling in some important gaps.